had a few years ago by Justice Scalia. He talked about what the word modify means. And he said modified, in our view, connotes moderate change. He said it might be good English to say that the French Revolution modified the status of the French nobility, but only because there's a figure of speech called understatement and a literary device known as sarcasm. We're talking about $500 billion and 43 million Americans. How does that fit under the normal understanding of modifying?
So, of course, I recognize that in MCI, Justice Scalia's opinion adopted a narrower understanding of that term, but I don't read that opinion to set forth a universal meaning of modify, no matter the statutory context. And here, of course, we have a broader phrase, waive or modify. It's undisputed, and the states aren't contesting, that the ordinary meaning of waive means to eliminate an obligation in its entirety. And I think if you look at that phrase in the context of the statute, that means that modify has to mean making a change up to the point of wholesale elimination. It would be really strange for Congress to say you can eliminate obligations altogether or tweak them just the littlest bit, but you can't do anything in between.
Well, but it's waive particular regulatory or statutory provisions.
That's right.
That to me suggests a much more focused use of the word.
Well, it's waive or modify paired with the authority to do that with respect to any Title IV provision. So I think that is the...
It doesn't say waive, modify or waive loan balances.
That's true, but it's very clear that under the Title IV provisions that are expressly referenced in the statute, things like repayment obligations, cancellation, discharge are core features of the program and obvious candidates for waiver in a statute, the central purpose of which is to provide debt relief to borrowers. You know, Congress itself has provided for loan discharge in other circumstances in response to borrower hardship. It's included provisions in the Higher Education Act for bankruptcy, for example, or for total disability or school closure, other kinds of hardships. And so it couldn't have surprised Congress one bit that in response to hardship posed by a national emergency, the Secretary might consider similarly providing discharge if that's what it takes to make sure borrowers don't default.
You think because there's a provision to allow waiver when your school closes, that because of that Congress shouldn't have been surprised when $500 billion is wiped off the books?
Well, I think it demonstrates that in a statute that's centrally focused on providing financial relief, that terminology should be given its plain meaning, and Congress could have anticipated that in a particular situation, you might expect that the way that you need to ameliorate the borrower harm is through loan forgiveness. And Mr. Chief Justice, maybe I can just use an example drawn from the initial context of promulgation of this statutory relief. It was initially a bill that was limited just to helping service members who were fighting in wars. And think about an example of a service member who goes off to war, and you can provide HEROES Act relief to ensure that the service member doesn't have to pay down the loan while the term of service. But if something were to happen that left that service member worse off because of his service, say a disability that doesn't qualify for total discharge, it makes perfect sense to think that Congress would have expected that the Secretary would have authority under this act to make the service member whole and to ensure, just as the plain language suggests, that that service member isn't going to be left worse off because of the circumstance that prompted his service in the first place. And so there's that first order question of whether you can ever do any debt discharge. And I think in that context, it's perfectly sensible to read this language to authorize that.